Good morning. My name is John Rogers, and I'm the Associate Director of the Division of Oil, Gas, and Mining. We are gathered in the Department of Natural Resource Building in Salt Lake City. Our petitioners, their witnesses are in Denver, Colorado, and we're seeing them electronically with their attorney here present in Salt Lake City. Today is Wednesday, July 27, 2017, and I've been appointed by the Board of Oil, Gas, and Mining to act as the hearing officer in this matter, which is docket number 2017-017, case number 139-47. In the matter of the request for agency of action for AXIA Energy 2, LLC, for and order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unlocatable owners within 3 1280-acre drilling units established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Colton Formation, comprised of all the sections 25 and 26, 33 and 34 of Township 2 South, Range 3 West, U.S.M, and sections 30 and 31 of Township 2 South, Range 1 West, U.S.M, Duchesne County, Utah. At this time, are you hearing us and seeing us all right at this point?
Yeah.
Okay, great. At this time, I'll take a representation of counsel.
David Bolda with Beatty and Wozniak on behalf of AXIA Energy 2 LLC.
And Steve Alder with the Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining, and I'm accompanied by Dustin Doucette, an engineer for the division.
Meg Oswald, Division of Oil, Gas, and Mining, and I'll be representing the hearing officer, John Rogers, today.
Okay, thank you. At this time, we will turn over to Mr. Bolda for his presentation.
Thank you, Mr. Rogers. I'd first like to introduce the witnesses that are appearing electronically from their Denver office. On the right of the screen is Mr. Rick Gallegos, the Vice President of Land and Business Development for AXIA Energy 2 LLC. And to the left is Taryn Frenzel, Vice President of Completions and Engineering. At this time, I'd like to ask that the witnesses be sworn in.
Will you raise your right hands, please? You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Now, procedurally, I'm going to ask that both witnesses be recognized as experts in their respective fields. I don't know if you'd like me to do that one at a time when we get to their testimony, or to do them both now. The resumes were collectively submitted as Exhibit A. They're both up here, and they've both been recognized as experts in their respective fields in the past. So you let me know what you would prefer.
Why don't we do it one at a time as they come up? And I've looked through their resumes and met with them in the past. Division?
Yes, we are familiar with both witnesses, and they have testified. As a normal course, we don't believe expert testimony is necessary. Opinions aren't required of landmen. Generally, they give fact testimony, and to the extent that you are going to want to qualify any questions as expert questions, I think I'd reserve the right to object at that time as to Mr. Gallegos as being an expert. No objection as to, I guess you haven't offered the engineering expert, so I'll withhold my comments, but that would be my comment with regard to Mr. Gallegos.
Okay.
Okay, continue.
Okay. I'll first offer a summary of the case here. Now, for drilling purposes, subject sections 25 and 26 and sections 33 and 34 of Township 2 South 3 West were established as 1,280-acre drilling units in cause number 139-140, which was entered on January 23rd, 2017, and then modified by the order on rehearing for modification, which was then entered on April 4th, 2017. These were The formations that were spaced were for the Lower Green River-Wasatch, Lower Green River through Wasatch, Colton formations and production from those formations. Sections 25 and 26 and sections 33 and 34 are both regular 1,280 acre drilling units. Now, subject sections 30 and 31 of Township 2 South, Range 1 West, which is the third drilling unit, were established as a drilling unit in cause number 139-138. Also for the same formations and production from those formations. Sections 30 and 31 are irregular governmental sections totaling a total of, 1,280.72 acres. True and correct copies of the 139-138 and 139-140 orders were submitted as Exhibit B. I'm not putting them up here on the screen. They're already filed in this cause. In accordance with the 139-140 order, AXIA planned to drill 2 of these long lateral horizontal wells that we're discussing today. They're both lay-down wells, one upon sections 25 and 26. That is the Butcher Butte number 26-131 EWH-23 well. And the other well is on sections 33 and 34. That is the Butcher Butte 34-34 EWH-23 well. A description of the tracts and ownership type within these sections were submitted with the request as Exhibits 6 and 7. That's pertaining to sections 25, 26, and 33, 34. I will point out at this time that as we were preparing for the hearing today and going through this, we noticed a couple errors in the description of the tracts. And I have in the hearing presentation, I have the correct descriptions, but we'll address that when we get to it. AXIA spud the surface hole for the well in sections 25 and 26 on May 12th of 2017, and on May 14th, 2017 for the other well upon sections 33 and 34. First production has not yet been achieved. Now, as to the other well, in accordance with the 139-138 order, AXIA plans to drill another additional long lateral horizontal well. This will be a stand-up well on sections 30 and 31, and it's the Butcher Butte 31-134H-21 well. A description with the tracts and ownership type were also submitted with the request as Exhibit 8 pertaining to these 2 sections, 30 and 31. And as I mentioned, AXIA has not yet spud this well. There are approximately 488 mineral interest owners within the 25-26 drilling unit. About 100 within the 33-34 drilling unit, and approximately 114 within the 30-31 drilling unit. Now, as to the 25-26 drilling unit, of those 488, I think there are about 24 that have not leased or agreed to participate. In many cases, that's because these individuals can't be located. There might also be some entities and some companies involved that own an interest of record but can't be located either. In the 33-34 DU, again, there's approximately 100 mineral interest owners. Only 5, I think, have not agreed to lease or participate. And in the 30-31 of the 114, about 10 have not agreed to lease or participate. Again, many of these these owners are unlocatable, which we'll discuss more about later. All other owners have either leased their interest or agreed to participate and signed a JOA. There are also a number of estates of deceased parties for whom, well, there's a few, I think there's 7 estates of deceased parties who are seeking to compulsory pool. And this will be discussed during Mr. Gallegos' testimony, but they've done a diligent search for the possible heirs or potential heirs of these estates, and they've tried to obtain leases where they can. However, until those estates have been probated, there's no way to definitively determine who all the heirs are. And that's why we're asking that those interests be compulsory pooled in case additional heirs are discovered. Now, official letters to lease or participate for the owners in this action went out in April. In some cases, in many cases, I think efforts to work with these parties or locate them began prior to that date. AXIA has continued to work with and negotiate with any of the parties that were willing to contact them and to lease or participate with their respective interest in these subject wells. So that went on even up through yesterday, I believe.
Mr. Bolda, could I just interrupt here for a minute?
Certainly.
As I read through this originally, I was somewhat confused when we're referring to each individual well or as a group of 3. Is there somehow you can kind of distinguish when you're referring to one well or the group of 3?
Absolutely.
Because I found it sort of confusing, and I don't know, maybe the division or other too. So
yeah, I'll try to point out most of the testimony is going to refer to all 3 collectively because they made the same efforts to contact or try to negotiate leases or participate. But there will be some instances where we're going to refer to specific wells or drilling units, and I'll be sure that I point that out where I can.
That'd be appreciated.
Yeah, absolutely. Okay, since and you'll see when we get to this exhibit, but there is a tribal lease and the BIA allotted lease involved, and so in order to pool all those interests where the BIA or the tribe is involved, you have to have a communitization agreement, but they won't approve that communitization agreement until we have a pooling order from the board.
again, which drilling unit was that in?
We will address that specifically. I think it's, I can't remember off the top of my head, I think it's in the 3334 drilling unit.
Okay,
but when we get there, yeah, we'll put that up and show. Now, Utah Code Annotated 40-6-211 defines a non-consenting owner as an owner who, after written notice, does not consent in advance to the drilling and operation of a well or agree to bear his proportionate share of the costs. The code also provides that an owner shall be deemed to have refused to agree to bear his proportionate share of the costs of drilling and operation of a well if the operator has in good faith attempted to reach an agreement with such owner. The owner and operator have been unable to agree upon terms for the leasing of the owner's interest or the participation of the owner's interest in the well. The testimony and evidence presented today will establish that the regulatory and statutory requirements to deem the unleased and uncommitted working interest owners, which are in the request defined as non-consenting FP parties, those requirements will have been met to show that they are non-consenting parties, as that term is defined in the code, and allowing them to be compulsory pooled within the subject wells. Utah Code Annotated 40-6.6.5 sets forth all of the terms and conditions to be considered and imposed by the board in a compulsory pooling hearing and order. And I'm not going to recite those here in detail. However, there are a couple of those terms and conditions I do want to initially point out. First, the board can impose a risk compensation factor, which commonly referred to as a non-consent penalty of no less than 150% and no more than 400%. As you are likely aware, AXIA has in this case asked for a 400% non-consent penalty for each of the 3 wells. And we will discuss that a little more in depth throughout the testimony today. And I think the testimony today will establish why, or the circumstances involving these wells, and justify imposition of a 400% penalty. Second, the next part of the statute that I want to point out is that the statute authorizes the board to impose the terms of a joint operating agreement upon compulsory pooled parties to govern operations as long as those terms are fair and reasonable. AXIA has requested the board to adopt 3 joint operating agreements, one for each of the 3 wells that would apply only to the respective well and not any additional wells or the whole unit going forward. Those were submitted as Exhibits G for the 25-26 DU, Exhibit H for the 33-34 DU, and Exhibit I for the 30-31 DU. And the testimony will establish that those contain fair and reasonable terms. The board has jurisdiction over this matter pursuant to Utah Code Annotated 40-6.5. Again, we'll get into this throughout the testimony, but a copy of the request was mailed by certified mail to the interested parties within the subject sections. The evidence will show that throughout the presentation will show that the return receipts that those were received, or will show the status of those mailings. I do want to point out, as I had mentioned earlier, we had a problem with it. We noticed a couple errors in the tract description. One of the parties, because of that error, one of the governmental agencies having jurisdiction was SITLA. There's a state lease, 2 state leases involved, and those were previously identified as fee tracts. They're actually state tracts. I spoke with LaVon Garrison yesterday. Even though we didn't include her in the certificate of service, she said she was aware of the hearing and had received a copy of the request. I have an email from LaVon Garrison with the Trust Lands Administration saying that they have no problem. They understand that the hearing is taking place today, that some of their leases are involved, but they have no objections. I can show that at any time throughout the hearing. Maybe when we get to the notification portion of the testimony, I'll put that up so you guys can see her email.
Would you want to put that in as an exhibit? Or?
Yeah, I think we should. So it's a part of the record. We'll identify it probably as Exhibit UUU when we get there. I'll make a note of that. Okay. As to those parties who could not be located because no current valid address could be found, or there's potential heirs or devotees of an estate that we can't, that we can't identify because there's no order distributing interest from the estate. We actually asked for and received from the board the ability to do a notice by publication. which was filed in the Uinta Basin Standard. It was published there and UtahLegals.com. We have an affidavit of publication from the Uinta Basin Standard, and showing that was in fact published. That's Exhibit YYY, which we will show during the notice portion of the request, or of the hearing. Notice of the request and this hearing was also duly published in the Salt Lake Tribune and Deseret Morning News on July 2nd, 2017, and the Uinta Basin Standard on July 4th, 2017. No, I think this is important, no responses were received by any of the notice parties. And the division has not filed a staff memorandum. Okay, that is it for the introduction and summary. I would now like to go to my first witness, Mr. Rick Gallegos. As I mentioned previously, Mr. Gallegos has been recognized as an expert in petroleum land management for purposes of cause docket number 2017-10, cause number 139-144. And his summary of his experience was submitted as Exhibit A. That is currently up on the board. With the board and the division, Mr. Alder's permission, I would like to have Mr. Gallegos recognized as an expert in petroleum land management. I have one expert question that I think is relevant and important to ask regarding the JOA, the Joint Operating Agreement.
Mr. Alder, do you have any objections?
Well, could we wait till we get to that question? And I would note, Mr. Gallegos, since AXIA probably, or your counsel, since AXIA probably prepared these, you probably appeared before the Utah Oil and Gas Board. We don't have a commission, and you should probably make a note of that for future use on your exhibits.
Yeah, we did notice that. It's that they refer to Colorado, Wyoming, Texas, Oklahoma. Some of those are commissions, and
Right.
maybe that should be clarified. But
Yeah, he didn't appear before the Utah Commission.
certainly, we understand that.
Thank you.
Okay, can you, Mr. Gallegos, can you please state your name and business address for the record?
Yes, Rick Gallegos, and my business address is 1430 Larimer Street, Denver, Colorado 80202.
Okay, and can you state your current position with AXIA?
Yes, I am the Vice President of Land, and I oversee all of the land activities for AXIA, including this area.
Thank you. Can you please describe AXIA's corporate and bonding status?
Yes, AXIA is a Delaware LLC in good standing and qualified to conduct business in the state of Utah and bonded with all of the relevant federal agencies.
Okay, at this time, I would like you to turn to Exhibit C. Now, is this prepared by you or with your input and review?
Yes.
Okay, can you please explain this exhibit that we have up on the screen?
Yes, the exhibit depicts the 3 units that we are seeking to pool today. It's got the 2 laydowns over to the west and the stand-up in 2 south, 1 west to the east. And then it also shows the underlying spacing units or spacing order.
Okay, thank you. Next, I would like you to please look at Exhibits D, E, F, and what will be replacements Exhibits 6, 7, and 8. Now, were these prepared by you or with your input and review?
Yes.
Okay. Let's go back to, first we'll go to Exhibit D and Replacement Exhibit 6. Can you please explain this exhibit?
Yes, Exhibit D is a exhibit that really shows the wellbore path of the well that we're going to be drilling in the units comprised of 25 and 26. It shows the surface location as well as the bottom hole location. And you can see there that it traverses through sections 26 and 25 with the bottom hole location there in section 25.
Okay, and the next page of Exhibit D?
Yes, this simply just depicts the different tracks within the section 25. And this depicts the different tracks within section 26.
Okay. And Replacement Exhibit 6.
What 6 shows is the various legal descriptions of the tracks, as well as the percentage of the unit which each track makes up in the section.
Okay. I haven't. This was discovered yesterday in the evening as we were going through it, and so I put it in, and I will ask that it be admitted. And I have, I think I brought copies with me. And Mr. Gallegos, this is the exhibit here. Also shows where those tracks were previously identified as fee, but have since been changed to state. Is that correct?
That is correct. Track number 6 was initially inadvertently identified as fee and has now been changed to state.
And on the second page, there's another track there, correct?
Track 11 as well.
So, Mr. Bowler, have you provided copies to the division of those?
I have not yet. I printed them off this morning. I have those with me. I can give you those now.
I would appreciate
Yeah.
having a copy before you ask questions about the exhibit.
It's also up on the screen.
It's kind of hard to see the screen from here.
This is 6.
Thank you.
Since this is where we're talking about that state tract that was previously identified as a fee tract, I thought maybe this would be a good time to show the email that I received yesterday from Levon Garrison with the Trust Lands Administration. I didn't prepare copies. It's up on the screen. But if we want to identify this as an exhibit, and I can submit copies to everybody later, if there's any problems reading this, let me know.
Would you like a copy of that?
Yes. I don't know if I should refer to you as Mr. Chairman or Hearing Examiner Rogers, but first of all, we need to see if that's the complete email, and yes, I'd like to have a copy. Also reserve the right to object to, since we haven't confirmed any of this. Okay, that's the whole email there.
This is the whole email. When I spoke to her on the phone, she asked me if I could send her an email so that she had my address. That's what the bottom portion is. That was my email to Levon, and then she responded, and that's her email at the top.
And if you could return to your replacement exhibit 6, so the division can understand the context. I'm not quite sure what changed in exhibit 6.
So if you look at track 6 here, where the cursor is, this says south half northeast. It was previously identified as a fee tract. This replacement correctly identifies it as a state tract. And then the same with tract 11. Where my cursor is, that's on the page 2 of the exhibit. It previously stated that it was fee, and now shows state.
So just to clarify this, previously everything was fee and there was no state listed on here.
Yeah.
And that's what LaVon Garrison's email is clarifying, that she's okay with you changing that from fee to state.
That she's okay with the hearing going forward, even though they weren't originally included in the certificate of service, because this was misidentified, this tract was misidentified as fee. So when the certificate of service was prepared to mail out a copy of the request, SITLA wasn't included. And so this is her stating that she's aware of the pooling hearing, and that AXIA owns the lease. We're not seeking to compulsory pool the state, since we can't anyways, and that's Tractor's lease that's owned by AXIA, and so she said she has no concerns with it moving forward.
I know, Mr. Alder, you'd like to have seen this beforehand, but since it's a fairly minor change in that SITLA has no issue with it, you want to continue on with that?
Yeah, I'd like to ask questions about the exhibit when you get through, so.
Okay. That's all the questions I had related to this exhibit.
Do you want, Mr. Chairman, would you like us to call you that? So can we ask questions about the exhibit now, or do you want us to wait until
Why don't you wait until we
cross-examination?
do a cross-exam?
Okay, thanks.
Okay. Okay, Mr. Gallegos, can you please explain Exhibit E?
Yes, Exhibit E is similar to what we just looked at, and it shows the wellbore path for the well being drilled in units comprised of sections 33 and 34.
Okay, thank you. And then the next page of the exhibit, Exhibit E, you explain this?
Yes, this depicts the various tracks within section 33.
Okay, and the next page, oops. Could you please explain what this shows?
Yes, this depicts the various tracks within section 34.
Okay. I also have, again, this was discovered yesterday as we were going through. I have a replacement Exhibit 7 that I can hand out to everybody. Same problem here. There was an error with the track description. However, all the parties here had been notified, included in the certificate of service. The mistake here was with identifying a tribal and BIA tract as fee, but it was actually like I said, a tribal and BIA tract. They are included in the certificate of service. They were notified of this hearing, and no response was received.
Mr. Bolda, like the last one, could you identify which lines were changed exactly?
So on tract 18.
Could we have the witness identify this?
Yeah.
Yes, it was track 18 that was changed to tribal.
And what was it listed before as fee?
It was listed before as BIA.
Oh, BIA, okay.
I don't see tract 18, do you? Yeah, but do you see it on the exhibit?
Yeah, it's on page 4 of that replacement Exhibit 7.
Line number 18.
Right, but on the original Exhibit E, we don't have 18 tracks. Unless I'm confused.
Well, maybe to eliminate some confusion here, so the original Exhibit E, as Mr. Gallegos just pointed out, after the plat showing the location of the well, the next page is a track plat, and it lists 11 tracks, and then the next page lists some additional tracks. These weren't all listed consecutively when they were submitted, but when we submitted the original Exhibit 7, we listed them, 1 through 18, so we didn't have multiples of 1 or 2 or 3. So the replacement Exhibit 7 and the original Exhibit 7 listed all of those tracks, and consecutively.
Be honest with you, that's a little confusing. And is there any way we could get an updated map or track that would show everything there?
We can, yeah, we can go and so we could resubmit it after the hearing, have them listed so consecutively from one section to the next, 1 through 24. There's 24 tracks on this, I believe.
It may be clear to you, but to us it's a little bit.
So you're not withdrawing the exhibits, you're just adding an additional exhibit.
That's what we would be doing.
And what would be clearer to me is to indicate that what you have shown as track 7 on the 3rd page of Exhibit E is also indicated as track 18, is that right? I mean, just, if you refer to these by exhibits, by track numbers, which we do, it's helpful to have them correspond.
Yeah, and we can, excuse me, we can change that to make sure these correspond.
To you, it may be straightforward. To us, it's sort of confusing.
No, I understand, and we can. That's simple to do.
Okay.
We can do that and submit an exhibit that shows that it's the same as the numbering there.
Okay.
Does one question, as long as we've interrupted, does track 7 include the dotted portion that appears to be a right-of-way, or exclude it?
It does exclude those, it includes those lands as well.
Thank you.
Okay. We will now turn to Exhibit F and what will be replacement Exhibit 8.
As with the others, Exhibit F depicts the well bore path of the well drilled in the units comprised of 30 and 31.
And this tract map is going to have the same issue, and we will replace for each of those exhibits D, E, and F. We will submit a new map that corresponds to the exhibit 6, 7, and 8, the numbering there,
Okay.
to make
We
that more
appreciate that for
clear.
clarification.
So we don't have to cover that again right now. I just thought I would point that out prior to getting to it. In any event, Mr. Gallegos, can you explain this page of Exhibit F?
Yes, it just depicts the various tracks in Section 30.
Okay. And the following one?
This one depicts the different tracks in Section 31.
Again, what was the change for Exhibit 8?
Was there a change?
What's that? Excuse me?
I think
Well, I assume there's a change if you
Yes,
replaced it.
yes, there is. On tract 8, one of the tracks was previously listed as fee. It's now shows a fee/highway that is managed by the Division of Forestry, Fire, and State Lands. There is a lease, and they also received notice of this action.
That's parcel 8.
Parcel
Tract-
8,
Tract 8.
Tract 8,
Okay.
Tract 21 is the same. And I believe that's all the changes there.
Again, just for clarification, it went from fee to fee/highway, and that is a forestry?
Yeah, the Division of Forestry, Fire, and State Lands, this tract is not managed by the Trust Lands Administration because this was a portion, it was part of a highway. And so it's not handled by the TLA, which you would probably use to dealing with state lands. And again, as we mentioned, we will submit an additional exhibit which properly identifies the tracks on a map that correspond to the numbers on the replacement exhibit 8, same with 6, 7, and 8. So. We're done with those exhibits unless you feel it's important to ask a question about that right now. I know Mr. Rogers asked that we proceed, but if there's something
Well, maybe
you'd like to
since
point
they're
out.
all kind of bundled together, you want to ask right now if you have any questions, Mr. Alder.
It might help clarify a few things. So starting with the last exhibit, replacement exhibit 7, again, this will not be a replacement, this will be an additional exhibit, clarifying exhibit E or F. Is that correct?
So on Exhibit F, for example, I will put this up on the screen. Exhibit F, the first page will stay the same. But yeah, we will submit an additional exhibit that will clarify the tracks with this page that's up on the screen now. So this is the second page of Exhibit F. The new exhibit will be sure to have all of the tracks match up with the track descriptions in the replacement exhibit 8. That's
So
there.
it won't be a complete replacement, you'll just replace this plat map.
Yeah, I can submit it as a new exhibit. It might be helpful to do it as a replacement exhibit so that when somebody is referring to it, you're not confused with, okay, well, what are these other plats?
Yeah, I think it would be helpful to have it as a standalone document, to have everything there. So if you looked at that, you could say, okay, this now replaces everything that happened before. Would
Okay.
that be
Yes,
okay?
that's
Division would use that.
Well, I think the map doesn't change and should remain except for the numbering of the tracks.
the
And-
numbering changes, correct.
And as far as the second page of Exhibit F, which shows tracks 1 through 6, there aren't any changes, although the information on the replacement Exhibit 8 is helpful. And I would suggest in the future that your exhibit should include the ownership and percentages in the original form, not, that would have been helpful to have had for the division to have had originally. But then turning to page 3 of that exhibit, that's where the changes occur. So that refers to what is tracked.
Begins with track 7.
Okay, yeah, that starts with track 7, you're right.
Yeah.
But it's tract 8, which has changed from fee to fee/highway. And that was my question, Mr. Gagos. Who were the fee owners, if you had fee owners listed, who were they?
I don't know who the fee owners are right offhand, but it was it was an undivided interest in the tract.
So this land is owned in fee by someone else?
That is correct.
And there's a right-of-way?
Yes, there's a portion of it owned, it's an undivided tract.
The minerals, correct, underlying the
Yeah, the minerals, I
right-of-way.
should say. Mhm.
So the minerals, are they owned in fee or are they owned by the state?
They're all, it's a split mineral ownership, owned by the fee and the state.
To what percentage?
I do not have that percentage in front of me.
You're sure of that? Do you have a document that would indicate how that's owned? That's very unusual for the state to split the mineral estate with the surface owner or
Yes,
with
we have a
someone
title
else.
opinion.
Mr. Gallegos, how was this particular tract identified, or how did you become aware of
Derived
it
from a title opinion rendered by a licensed attorney.
in Utah?
That's correct.
The same one that did the other two drilling units that you've talked about?
Yes, I think it was.
And that's the same one that misidentified minerals
No.
owned by the tribe as being owned in fee and misidentified Sitla property as being owned in fee?
That was not, we actually, and I was just checking, we did notify Sitla on the certificate of service. Sitla was notified, and that was not a mistake of the attorney there. That was the mistake of the contract landman that put that together.
They put that particular exhibit together, not
That's-
the tracks in the title opinion, correct?
So
That's
was anybody given notice within the state of Utah of the minerals that are owned under tract, currently on this new exhibit, identified as tract 8 and tract 21, the highway?
Was the managing agency for this tract of land, the Division of Fire, Forestry, and State Lands, notified of this request?
Yeah, that was my question.
Can you hear me? Are you there? I think we have a sound problem.
Yeah,
We're here.
no, I can hear you, Dave.
Oh, okay. Did the question that was asked is as to those tracks 8 and I think 21, where the mistake in preparing the exhibit was made, was the Division of Fire, Forestry, and State Lands notified of the hearing and included in the certificate of service?
I'll have to look at the certificate of service here real quickly.
Yes, it's on the last page. You'll see that you'll find the name there.
Okay, yeah, yes, they were notified.
So to clarify, they were notified because we were aware that this was a highway tract, but the mistake was when this exhibit was prepared, instead of including highway, it was simply marked fee, correct?
That's correct. The mistake here was by the contract landman. And that's what we caught yesterday.
So are you attempting to force pool the state with regard to these lands, or you obviously don't have an agreement with them yet?
Yeah, we are not attempting to force pull them, no.
So have they agreed to lease? The state, I mean.
These lands are under lease. Now, in one case, there's one where the sale has happened and the lease is yet to issue. But over in section 31, the lands are under lease.
So,
So we are not attempting to compulsory pool the state.
Right.
Not at all.
we're not, and it was just simply it's simply a misidentification of the tract ownership as opposed to not being.
Hello?
Can you hear us, Rick?
Yeah, we can. The call got dropped somehow. But
Yeah,
we're
we
back.
just reinitiated it, and I think we're back online. Everything good, Paul? Okay. Okay, I had a question, now I can't remember it. Okay, now I remember. When you have a fee/highway/state forestry, was the fee owner also notified, and do they consent to lease on this?
The fee owner would have only been notified if they were, it was an unleased owner in this case. And I believe in this situation, they were already leased. Section 31, just to let you know, Section 31 already has a producing well on it. So there was very little in the way of unleased mineral owners in that sections 30 and 31 because they already have wells on them. What was, for the most part, being forced pooled on 30 and 31 was working interest owners.
Okay. Okay, thank you. Back to you, Mr. Alder.
Well, this is a little irregular, but I guess it's kind of an informal hearing, so I appreciate the allowance to do that. The question that we had, and maybe this should go back to Mr. Boda, but just some foundation about exhibits, the replacement exhibits. Who prepared them? What were they based on? When, obviously, when was it? You said the error was discovered, but who discovered it and that sort of thing? So,
Okay.
I'll go ahead and address that. I discovered those errors, and when I was looking at it yesterday, because I knew in talking with the state, because we talked to them about one of their tracks, and certainly the state was notified in the certificate of service, but it was inadvertently shown as a fee tract, and that was done by our contract landman. And I discovered that when I was reviewing that yesterday and brought that to Dave's attention so we would get that straightened out.
And the information that was provided for this exhibit to make that correction, that was given to me by you, is that correct?
That is correct. And
then I fixed the exhibit, made the corrections, and you reviewed it to make sure they were correct.
I think that's what he's doing. That is right.
Okay.
Well, you're correct, Mr. Alder. We got to add a line here. So if you have any more questions for 6, 7, or 8, let's address those now. Otherwise, we'll let Mr. Gallegos finish his testimony.
Yeah, no other questions at this time.
Okay. I just want to clarify for replacement exhibit 6, 7, 8, Mr. Bolda.
Yes.
I would prefer to have the whole thing replaced. So down the line, if someone says this, replace that, we're not trying to figure out what part was replaced and what wasn't. I think it'd be clearer in the future. Because we're confused now, I think down the line it would make it even more difficult.
I agree. If somebody's going back through
Yeah.
this to see what was included, what the tracks are, the parties involved, it'd be better to replace it.
Yeah, the whole thing.
Yes.
Okay, great. Okay, continue on.
Okay. Okay, Mr. Gallegos, this question was already asked, but it applies to the next exhibit or few exhibits. So I would like to ask it again. How were the tracks determined and individual ownership within the subject sections determined?
It was done by title opinions rendered for AXIA between September of 2012 and February of 2017 by a licensed attorney. And then they were updated in the county records by our contract landman.
Okay. I'd like you to please now look at second replacement exhibit 1. Now these were submitted prior to today. Replacement exhibits 2 and 3 and exhibits 4 and 5. If you could look at those, were those prepared by you or with your input and review?
Yes, they were.
Okay. Let's go first to second replacement exhibit 1. And can you please explain this exhibit?
Yes, that exhibit identifies the parties that we are seeking to be compulsory pooled in sections 25 and 26 to South 3 West.
Okay, and currently, on the board. On the first page, it shows as one of the parties that's we're seeking to force pool is EP Energy. Can you are there any unique circumstances with EP in this section and pertaining to this well?
Yeah, in regards to EP, we have got an arrangement with them to acquire their interest in that sections 25 and 26, and we had actually have completed a transaction, but we've got some cleanup work to do to get it all taken care of.
Okay, and so at some point in the near future, AXIA expects to own this tract, this working interest.
So at this point in time, you would not expect a force pool then?
We probably would want to go ahead and force pool them for right now, but it is our intent to get that cleaned up.
And if maybe this isn't a question that should be directed towards Mr. Gallegos, but just because they were compulsory pooled, if for example, if this other party didn't hold up their end of the bargain and get these things cleaned up, then they would still need to be compulsory pooled, and that's why they're still included on this exhibit. If it does get cleaned up and AXIA ends up with the interest, then AXIA would not charge itself a penalty because it was compulsory pooled in this hearing today. That's still it would still be for there would be no penalty assessed. AXIA would own the interest.
But I guess my question is, have they shown a desire to participate, or they're thinking about it?
In sections 25 and 26, they do not have a desire to participate. However, I will say in sections 30 and 31 of this same hearing, they have elected to participate and signed a JOA, and we just received that yesterday, and we'll be dropping them insofar as the pooling pertains to sections 30 and 31.
As I mentioned in my summary of the case, the AXIA was they were willing to continue to work with.
So, and this is where it gets a little confusing because they were doing 3 separate billing units.
And we'll get to 30 and 31 and the situation there. For purposes of this hearing, we just wanted to point out that they are still included. The point to make was that they're still included here, but we are going to remove them from a different well because they have signed a JOA and agreed to participate and elected to participate. So when we get there, we'll address that.
So as you go forward with this exhibit and as to that party, could you clarify whether how their interests are treated for purposes of determining the royalty? And
yes, Mr. Gallegos. So this is a working interest from EP. So they own a lease or leases in this within these sections, correct?
Correct. So for royalty purposes, the mineral owner would be under lease, so they would get the royalty as provided for in the lease. And in this case, EP would not get a royalty because they're a working interest owner.
But the lease that EP Energy owns in this case, was it calculated in the weighted average royalty?
Yes, it would have been that. Yes.
Correct.
thank you.
Okay.
Sorry to interrupt.
That's fine. It's good to get that clarified at this point.
Okay. Again, to summarize, this Exhibit 1 pertains to sections 25 and 26. And as I mentioned, this is a exhibit already filed. Moving on to the next exhibit, Replacement Exhibit 2. Again, this was filed, I think, a week and a half ago. You have this. Can you please explain what this exhibit shows?
Yes, this is a listing of the parties that we seek to force pool or compulsory pool in sections 33 and 34.
Okay, and in this case, there are only two parties for this section 33 and 34 well, correct?
Correct.
Okay. Next, replacement exhibit 3. Again, not to be confused with the earlier replacement exhibits. This one was filed prior to the hearing. You should all have this. Can you please explain this exhibit, Mr. Gallegos?
Yes, this is a listing of the parties that we are seeking to compulsory pull in sections 30 and 31.
Okay, and previously you mentioned that EP Energy, as it relates to this well, had elected to participate. At the time of filing this exhibit, they'd elected to participate but not yet signed a JOA or tendered the cost. So can you please explain the situation with EP Energy in this particular well and drilling unit?
Yes, EP has since signed a JOA. We received the executed JOA yesterday. So it is our intent to drop them from the forced pooling as it pertains to sections 30 and 31.
So any findings of fact that were requested by us where we would list the parties that we're seeking to compulsory pool as of this hearing date, we would then leave EP Energy out.
So is that represented in a replacement exhibit 3?
Well, no. This replacement exhibit 3 was filed.
Previous.
Yeah,
Okay.
yeah, we can have it. So this just happened yesterday,
Okay.
where they received the JOA, and so we just wanted to point out at the hearing today that as to sections 30 and 31, EP we're no longer seeking, or AXIA is no longer seeking to compulsory pool. And next, Exhibit 4, can you please explain this exhibit?
Yes, that is the listing of the names and estates of the deceased parties for sections 25 and 26.
And in the request, the heirs or the potential heirs or devisees of these parties were described as unknowns. Is that correct?
That is correct. When the title opinions that we received for these had no corresponding addresses.
And so it listed ownership for these interests, and the title opinions were described as either, for example, the first one, R.C. Crabb deceased, or the estate of R.C. Crabb, or the heirs and devisees of R.C. Crabb, correct?
That is correct. And then we did do some additional searches, internet searches, and also check of the county records just to update that, and we were unable to locate the addresses for these particular estates.
Correct. And where the title opinions identified probable heirs, did you reach out to those probable heirs to try and get leases?
In the event that we could find an address.
Correct. And this is for, again, this pertains to sections 25 and 26. There is no corresponding exhibit for sections 33 and 34. And can you explain why that is, Mr. Gallegos, why we don't have a state of deceased parties that we're seeking to compulsory pool for sections 33 and 34?
Because we did not identify any there.
All right, so the title opinions did not identify any deceased parties'
That is
estates,
correct.
correct? Okay. So then Exhibit 5, please explain this exhibit.
That is an exhibit that lists the names and estates of the deceased parties for sections 30 and 31.
Okay. Thank you. Turning now to exhibits P and X were these prepared by you or with your input and review?
Yes.
Okay. Now, can you please explain for everybody here what these exhibits are and what they're representative of, and why all the exhibits showing well proposals or lease offers are not being covered here during the presentation?
Yeah, for these, we'd have exhibits P through TTT, so it would be very large, and we didn't want to. So what we did is we just have one to represent the well proposal on exhibit P, and then for exhibit X, it's our offer to participate or lease for unleased mineral interests. And the well proposals, if we go to look at that, all these well proposals were sent out by certified mail to the working interest owners, and attached thereto was a joint operating agreement and the AFE, which gave them the election to participate.
Okay.
Then if we turn to exhibit X, that is the letters that were sent out by certified mail as well to all of the unleased mineral owners, which were given them the opportunity to either lease their minerals or participate.
Okay. And to clarify, the exhibits that were submitted by the exhibit filing deadline include all of the return receipts and well proposal letters and lease offers that were sent out, correct?
That is correct.
And those are identified as exhibits P through TTT, correct?
That's correct.
Okay, thank you. Now, let's see. Now, for those parties that could not be located in this case, if no valid address could be found, and whether through the title opinions or through searches of your own and internet searches, how did we or how did you go about notifying those parties that were identified as mineral interest owners but could not be located?
Well, we requested and received permission to provide notice of publication.
Okay, and there's an exhibit that will address this, which we will discuss shortly. Utah Code annotated 40-6-6.5 subsection 6 provides a compulsory pooled unleased owner is entitled to payment of the average weighted landowner's royalty during the payout period. At this time, I'd like to turn to exhibits, what are identified as replacement exhibits M and N. Again, these replacement exhibits were submitted, were filed yesterday. The board, the chairman signed an order granting leave to file these replacement exhibits, and these replacement exhibits were necessary because additional parties had leased, and just up until recently. So we will turn to replacement exhibits M and N and exhibit O. Mr. Gallegos, were these prepared by you or with your input and review?
Yes.
Okay, now I understand that the lines are small here. This is difficult to read. But can you please explain what replacement exhibit M shows, and we'll go from there.
Yeah, this is the weighted average royalty for those fee owners only that we had leases on in sections 25 and 26.
Okay, and so this shows the calculations for each lessor within the drilling unit, correct?
That is correct.
And on the final page of replacement exhibit M, what what do you find there? What does that show?
Yeah, that is 16.745789%.
And what?
And I will say the reason that we always have to send replacement ones on this is because we do allow folks up till really the last day, if they want to lease their interest as opposed to being forced pool, we're very flexible with them. So we accept these leases as they come in, really up to almost the last day.
Okay, thank you. And then replacement exhibit N is the same thing, correct? But for which drilling unit does that pertain to?
Yes, N is for the drilling unit comprised of sections 33 and 34. And same thing, it's the weighted average royalty for those fee leases that we've acquired. And the average royalty on that one is 18.702148%.
Okay. And to clarify, that includes all the leases within those sections, not just the ones that you acquired, correct?
That is correct. That's all fee leases that we show from our title opinions for sections 33 and 34.
Okay, thank you. And then no replacement exhibit was filed for Exhibit O. No additional parties had leased, and so this is the original Exhibit O. And Mr. Gallegos, what drilling unit does this pertain to, and what is the average weighted fee royalty calculation?
Yeah, once again, this is the weighted average royalty calculations for, in this case, it's for sections 30 and 31. And the average royalty is 16.839035%.
Okay, thank you. Okay, that's all the questions I have on those three exhibits. I'd like to move now to discuss the joint operating agreement and the requested non-consent penalty. Utah Code Annotated Section 40-6-6.5 2C allows the board to adopt terms of a joint operating agreement to govern operations as between the consenting and compulsory pooled non-consenting parties. So at this time, I'd like to, you, Mr. Gallegos, to turn your attention to exhibits G, H, and I. And were these prepared by you or AXIA personnel with your input and review?
Yes.
Okay. Now, our exhibits G, H, and I materially the same except for the well to which they apply.
To the well and the lands. Yes.
Correct, to the well and the lands. Now, we'll start here at Exhibit G, and I mentioned that I would point out when we're, I try to point out when we're referring specifically to one well or one drilling unit or all. Exhibit G pertains just to the well in sections 25 and 26. As Mr. Gallegos just stated, exhibits G, H, and I are the JOAs, and there's some, I think, close to 100 pages each. Rather than going through each JOA here at the hearing, we've pulled a few selected pages from Exhibit G, which are also the same in Exhibits H and I. But we'll cover this, and then I'll show you the first page of Exhibits H and I, which are the JOAs for the other two wells, so you can see that those exhibits, the only reason that they're different is because they pertain to a different well.
Okay, that'll be fine.
Okay. Okay, so Mr. Gallegos, can you please explain this exhibit and what's shown on the first page of Exhibit G?
Yeah, Exhibit G and what we used for all units, as David mentioned, they are the same except for the well and the lands. And we use the AAPL 610 Model Form Operating Agreement that is very standard in industry. This is the cover page for it that references the well and the lands to be pulled.
Okay, and are these exhibits that we are showing here, are they materially the same as the exhibits signed by other working interest parties?
Yes, they are.
That have agreed to participate?
Yes.
Yes. Okay. We'll go to the next page, which is page 11 of the JOA Exhibit G. Can you explain what this exhibit shows, or this page of the exhibit shows?
Yeah, what this page shows is the non-consent penalty, and it's basically it's 100% for surface equipment, and then 400% for everything downhole, and for all the drilling activity as well. And so this same 400% penalty has been agreed to without change by all of the other working interest owners that have signed the JOA.
Okay. Thank you. Now, can you explain for the board why we are requesting 400%? Also keeping in mind that Mr. Frenzel, when we get to his testimony, will discuss that non-consent penalty and the risk factors involved.
Objection
Yes.
is to the qualifications, if you might establish foundation or the basis for his testimony on this point.
Yeah, certainly. This is where the expert opinion question will come in when we talk about what is industry standard, is the standard among industry partners, and so this is why as we get here in the next page, 2 pages of the exhibit, why I asked that he be qualified as an expert in petroleum land management, because I think it is relevant to show, based on his experience and his expertise, is this a standard a risk penalty to be imposed, and are the other charges that will be shown in the other exhibit, are those standard among industry partners?
Okay, well, before Mr. Rogers, I would just like to ask for more foundation and interpose an objection to the question of this witness, since I don't think that's one of the criteria that plays into whether or not what the amount of penalty is within the range provided for by statute.
Well, earlier in the hearing, you declined to accept him as an expert, and you want to do it later on?
Yeah, this would be the time if he's going to testify as to his opinion as to the reasonableness of the 400% penalty they're seeking. I have 2 objections. One is I'd like more foundation on his expertise, and secondly, I'd make an objection to the question being appropriate in any event, since I don't believe that's a criteria for a risk penalty.
Okay.
Well, why don't this time we go back to his foundation and get
Certainly.
his expertise, and then we'll go from there.
Certainly. Up on the screen is Mr. Gallegos' qualifications. As I mentioned before, in the previous compulsory pooling, we did cause number 139-144. Mr. Alder had no objection to recognizing Mr. Gallegos as an expert in petroleum land management for purposes of that cause, and the same question was asked then and was not objected to at that time. I understand that typically a landman is a fact witness. And I've usually abided by that and not asked that petroleum landmen be qualified as experts. However, in certain other causes, parties objecting to the request that we made, where we didn't have our petroleum land witness be qualified as an expert, the other party's petroleum landman was qualified as an expert. So again, for purposes of this cause, and based on him being recognized as an expert in previous hearings, we can review this and we can go through each portion of his experience if you would like. But I would ask that you direct me on if you would like me to ask him these questions.
Yeah, Mr. Alder, would you like to accept him as an expert?
Well, I don't think that the fact that he testified once before in another matter at which the issue of a 400% penalty, I don't believe was before the board, qualifies him to testify as to whether or not a 400% penalty is reasonable. In this case, the fact that we didn't object before doesn't mean we don't have objections now. I think obviously the witness can testify as to his knowledge as to what the penalty is in other JOAs that he's signed or that his company signed. I just don't think he has his opinion as to whether it's reasonable is appropriate.
Okay, Mr. Alder, we'll withdraw our request that he be recognized as an expert based on your objections, and we'll just proceed so we can get on with the testimony of Mr. Gallegos.
Thank you.
Mr. Gallegos, on this this portion of the exhibit that you just referred to, have all the other parties that have agreed to participate, did they agree to a 100/400 non-consent penalty?
Yes, they did.
Okay, and in this case, why are you asking for a 400% non-consent penalty?
Well, we believe this is consistent with other operators in this area as well. As a non-operator, the JOAs that we've seen, we have signed, and that our predecessor has signed, have been at that 400% level as a non-operator, and that's very consistent in this area, and that is what we've done. I guess in addition, and Tara will elaborate on this later, but these are the first wells drilled, horizontal wells drilled in these sections to these zones, so they don't come without risk, and I think we're the first ones to do a laydown unit over on our two western units. So that certainly has an element of risk as well. And I will let Tara elaborate on this later.
Okay, thank you. All right, let's go to the next page of the exhibit. Can you explain what this Exhibit C to the JOA? This is not an actual exhibit this is part of the JOA exhibits. It's labeled as Exhibit C in the JOA itself.
Yeah, this is the standard industry form. It's called the COPUS form, accounting procedure, that is attached to virtually every operating agreement I've ever seen, and it governs the accounting procedure and on the operations. Okay,
and we point this part of the exhibit out because Utah Code annotated 40-6-6.54 D3 provides that the board may impose a reasonable interest charge, and as is been customary in the past. Page C3, the next page of this exhibit. Excuse me, find it here. Okay. So on this page, can you please explain this page of the exhibit, Mr. Gallegos?
Sure. On 3B, provides for a interest rate on unpaid balances of the prime rate published by the Wall Street Journal plus 3%. And that is what has been agreed to by the parties that have signed the JOA and is really pretty standard in industry.
Okay, what is the purpose of imposing a 3% interest rate on chargeable costs and expenses?
Well, it's the,
I'm sorry, the 3%, the prime rate plus 3%.
it is the rate that we charge on the unpaid balances.
And what is the purpose of that, of charging those, the interest rate? Let me rephrase that. In your opinion, you stated that this is standard form that's included in all JOAs, and in your opinion, is it to encourage timely payment of those costs and expenses? And
yes, it is, because it is only applicable to the balances that are 30 days overdue, that
Okay.
are overdue, that have not been paid. Let me qualify, have not been paid within 30 days of receipt of notice.
okay, thank you. Sorry to make that more complicated than it should have been. Okay, page C9 of the COPUS. It's just the next page that we have on the screen. Can you explain what this shows here?
Yes, what that is, it shows the drilling overhead rate and the producing overhead rate. And the drilling overhead rate is $10,000 a month. The producing overhead rate is $1,000 per month. And this has also been agreed to by the parties that have signed the JOA. And we've seen higher from other parties that are operators, so we think it's very fair and reasonable.
Okay, and is this part of the exhibit and the other pages, is this commonly accepted by industry partners and included with the JOAs that you've been a part of?
Yeah, yes, it is.
Okay. Again, we mentioned that we would show the first page of the other JOA exhibits which pertain to the other two wells. Currently up on the screen is Exhibit H. Can you just point out, Mr. Gallegos, can you just point out what this JOA exhibit, which well and lands it pertains to?
Yeah, this is just simply the cover page for the JOA for the Butcher Butte 34-34 EWH-23 well.
Okay, and the next page, Exhibit I.
That is the cover page for the Butcher Butte number 31-134H-21 well.
Okay, and as you previously testified to, the pages of the JOA that we had shown previously, those are all the same as were contained in these other JOAs, except for the well and lands which it pertained to, correct?
That is correct.
Okay. Okay, at this time, Mr. Gallegos, I do not have this on the presentation. This is a pleading that's already been on file in this cause. Can you please turn to the certificate of mailing? Do you have that in front of you?
Yes, I do.
The certificate of service, okay. And was this prepared by you or AXIA personnel with your input and review?
Yes.
And do you recognize the names on that list?
Yes, I do.
And what are they?
These are the, excuse me, the names and addresses for those parties that we seek to compulsory pull.
Okay, and those for the locatable parties, correct?
That's correct.
And where did these names? How are these names derived?
They were derived from the title opinions that we had received from our attorneys, as well as any updates from the contract landmans, either through a search of the county records or through internet searches as well. And then also kind of searches of the online records of the Utah State Court database for probate filings.
Okay, thank you. Now, I'd like to turn your attention to Exhibit ZZZ. Can you explain what this exhibit is?
Yes, Exhibit ZZZ, these are the green cards that confirm receipt by these parties of the RAA.
Okay.
And these were all the green cards that were received by AXIA as of July 24th, 2017.
Okay, and this exhibit also contains status updates for any certified mailings where the receipt, the green card, as you referred to, wasn't received, correct?
That's correct.
And so if a green card hadn't been received by July 24th, were you able to update the status through the United States Postal Service website?
Yes, we were. And as you can see there, some of these are there with the parties and they're available for pickup.
Okay, so this is again, this exhibit is the list of all the parties with that were identifiable and had locatable addresses, and this exhibit shows the status of the mailing or receipt of the mailing of the request, correct?
That is correct, and this is for the ones that we have not received a green card, a confirmation of receipt back, but it does show confirmation of delivery.
Okay, thank you.
And one thing I wanted to qualify real quickly is earlier I believe I misspoke on the certificate of service. We did give the state of Utah Department of Transportation notice of the RAA, but that was I think that earlier I had mentioned that was really SITLA, and that was not SITLA. SITLA was handled earlier by the email to Levon. So I just wanted to qualify that.
Okay, thank you. Now, as to, again, this is for the locatable, identifiable parties. Now, as to the unlocatable parties for whom no valid address was shown in the title opinions or could be found through your investigations, what was done in those cases? Or what kind of searches did you do to try and locate those parties?
Really the same as we did with all others is we've checked the county. We tried to update the county records to see if by chance something had been filed that would note their address. The contracts landman also did various internet searches, and then the online records of the Utah State Court database for probate filings.
Okay.
And as to those parties that were unlocatable, we did file a motion with the board to provide notice by publication, and that was granted.
Okay, and that is this next exhibit, correct? Exhibit YYY. So can you explain what this exhibit shows?
Yes, that is a copy of the affidavit of publication that we filed. That this provides evidence of service by publication to the unlocatable and unknown parties, as described in AXIA's amended ex parte motion for service by publication filed on June 15th, 2017, and granted by the board in its order dated June 22nd, 2017.
Okay, thank you. Mr. Rogers, this concludes my examination of Mr. Gallegos.
Okay, thank you. Mr. Alder, does the division have some questions for Mr. Gallegos?
Yes, we do. Could we just take a 5-minute or so break so I can consolidate questions?
I'll give you 10 minutes, okay?
Thank you.
Okay, thank you.
Did you catch that? We're taking a 10-minute break.
Sure.
Okay.
Well, should we leave this on? That way we don't get disconnected. We'll just leave it on.
Yes. The audio will be muted, but the video will be kept live. So you won't hear anything from our end, I believe.
All right.
Ms. Gallegos, can you hear us now?
Yes.
Sound like a commercial then. Okay, we'll go back to Mr. Alder for his questioning.
Mr. Gallegos, appreciate your patience with the questions previously, and I appreciate all the work that this is for your company to submit these notices and this information. I guess I want to make a statement and make sure that you're comfortable understanding that the purpose of my questions is that we are affecting mineral interests, property owners' rights to the shared in the production underneath their lands, and under Utah law, it's important that those parties, that reasonable efforts are made by companies to give those parties notice of the well that's being drilled and their rights to either lease or participate in that well. And it's not easy, as you know better than I, to do that. So these questions are to not discredit AXIA's efforts, but just to make sure that that effort has met the legal standard. And in that regard, I wonder if you would just explain to the hearing examiner the process that AXIA uses. You have several times mentioned you use an attorney, and then you used a landman, and then you apparently did some review. Could you just explain what each person did and when you transferred from the title opinion to the landman? And I'm particularly interested in these errors that popped up at the very last minute.
Yeah, I'll just kind of go over the process of what we do is that we have, the first thing that we have done is an abstract of title ran on the lands. So I'll just say we'll look at one section. So we have someone go out there and they build an abstract for us, and that abstract is comprised of every document that is recorded that is indexed to that legal location. So that abstract is then given to a licensed attorney, and they go through that abstract, and it'll be from inception to whatever date they certified at, the abstract is certified at. And they will render a title opinion that identifies all of the owners and their ownership. So that'll be working interest owners, leased owners, override owners, unleased mineral owners, and that is done by a licensed attorney. And obviously, we rely on that. Now, when I say that we have the landman look at it, in addition to that is a lot of times on these old estates, there's just very little records. I mean, you've got generations and generations of folks that have lived out there, and it may you may have a 40-acre tract that started out with one individual, and over the generations, it's owned by 30 people, and of those 30, we're not even sure if the wills were probated, who the heirs are. It's very hard to figure out who those heirs are. And so after we get the title opinion, it's certified to a certain date. So maybe it's certified, for example, through January of 2017. Then we go out and have the contract landman look at the county records as well from 2017 on to see if something's been filed in the county records subsequent to the certification date of the title opinion. And so in a lot of these cases on these estates, when the title opinion was rendered, there was nothing in all those documents that were indexed that showed us what the addresses were or who their heirs were. It just not that information is just not available. So what we'll do then too is we will try to look on the internet, and I have the contract landman do that at various different sites to see if that address doesn't pop up under that scenario and be out there and where it's not indexed in the county.
So in this case, did you update the title opinion through the efforts of an attorney after the lands were spaced?
We updated, in most cases it was the certification date of the opinions were after the lands were spaced, but then between that time and now, the filing, when we filed this, we had a contract landman go check to see if any other documents were filed that may impact the ownership.
So I'm not sure I understood your answer. You had to abstract and have a title opinion in order, and gave notice in order to space these lands.
No, that's not necessarily correct, because when we space the lands, that's different from the pooling.
Right.
When we're spacing the lands, we have within the spaced area, the area that's actually being spaced, in those cases, generally we can pull a lot of the information from the title opinion and then update it to a contract landman. But remember, on the spacing, you've also got to notify all those offsetting sections if you're crowding them.
Right.
Them, and then we don't have any title opinion on that, and to render title opinions on that would just be excessively costly.
Yeah, excuse me.
Under that scenario, we have a contract landman go out there and run the records to come up with the name and address list.
Yeah, there's a lot I don't know. But as to the lands in these sections that were forced pooling, you previously had a title opinion and gave notice to those individuals who were identified in that title opinion of the space.
That is correct.
And did you have that title opinion updated between then and this preparation of filing this request for agency action?
Yes, we did.
And by an attorney?
No, the title opinion at that point was by a contract landman that went out and checked the records to see what else had been filed out there, what other documents had been filed.
So there's been update by the contract landman from the date of the, whatever that date was, that you got the title opinion prior to spacing. Who was the land, is there one landman or one land company that you use or used?
We'll use, it depends on how busy we are. We may use different land folks if we're real busy, and depends on what we've got them working on. So
with regard to these 3 wells, did you use the same landman or different companies for each of the 3, I don't mean wells, 3 drilling units that were spacing? I guess they are 3 wells, yeah.
Yeah, I believe in this case it was the same landman.
Okay, and that person updates the abstract, so he goes to the county records. Is that right?
That is correct. And he looks for anything that's been filed subsequent to the certification date on the title opinion. And I will say in this case, 25 and 26 is one of the worst I've seen. As David mentioned earlier, there were 488 owners in there. And we've got arrangements or leases or with all of them except for 24. So, and this is just, I mean, it really is, it's very old title. It's been through multiple estates, and it's tough tracking down just trying to figure out who the heirs are, who the
right.
owners
Well,
are.
I guess I'm pressing on this because there were those heirs that were identified, and you indicated that they were not heirs of title, but heirs of the landman. And so is that the landman that we're talking about who misidentified? Did he misidentify? What's the nature of the failure to realize that 80 acres are state lease?
Yeah, the landman that I had doing that is a new landman that we have working in-house in Denver, and I had them preparing those documents, and I think it was just she is actually very, very good, and I think it was just a matter of she didn't catch that it was, being state.
So
she identified the tracks, but it was a different landman that I have going out and checking the county records.
So are you saying that the exhibits were prepared by that person who made the error, that that person was not responsible for internet searches or probate searches?
That person was not, no, I had a different land person that was going out and checking the county records. We have a land person that's based in Vernal that would do that.
Okay. Turning to the notices that you sent to the people, and I guess that's part of Exhibit P. Do I understand that Exhibit P includes notices that were sent to people who were leased and to people who were not leased?
No, P was, let me find it real quick. I believe P was the letter just to working interest owners. And X, yeah, P was the well proposal to the working interest owners, offering them the opportunity to participate in the well. And X is different. X was the letter to the unleased mineral owners, giving them the opportunity to either participate in the well or lease their interest.
Okay, well, I have one packet that's labeled Exhibit P, and it's held together with a big binder, and I assume it's all one exhibit. Oh, it's all the different exhibits.
Yeah,
all right, so that's confusing. So in Exhibit P, first page is a sample letter, April 26th, to Linn Energy, Linn Exchange, excuse me, Properties. You see that?
That's, yes.
Is that the same letter that was sent to, and who was that sent to? What kind of owners?
Working interest owners.
Non-leased or leased?
Yeah, the working interest owners that have a lease.
That have a lease, okay. That's, and so with regard to that, the last paragraph says, if we do not receive a response from you by the close of business on June 10th, Linn will be, by default, I'm not reading that exactly correct, Linn Exchange Properties will, by default, be deemed to have elected not to participate in the drilling and completion of the test well. That seems inconsistent with your statement that you're willing to work with these people up as long as possible.
Yeah, what we're doing there is we're trying to give them at least 30 days notice to make an election, but we have also decided to, if someone wants to come in last minute, and as EP has in 3031, that we will allow them that ability to do so.
Have you communicated that to them in any form, by letter, or in writing, or by telephone?
I've talked to several working interest owners that have elected subsequent to that. That is, I have not communicated that in writing to them, but I have communicated that verbally to them, and demonstrated so by the fact that we do that and have done that.
So what is your cutoff date?
Our cutoff date is really yesterday, the day before the hearing. I mean, we can't, once the hearings come through, and actually, in this case, I will tell you this, we're working with Linn Exchange Properties right now. They had a change of landman and kind of dropped the ball on this well proposal, and they do not have their JOA signed.
So are you willing to extend that deadline until the board hearing?
Yes, I am. I am willing to extend it for the next few weeks.
Do you think it's correct for you as Vice President of Land for AXIA to tell someone that they will be deemed not to participate, to elected not to participate? Do you have that authority?
Well, I think it is correct to set a deadline, because if we don't set a deadline, it will never happen. I mean, we certainly, I don't believe, have to give them this opportunity to participate. What we're trying to do is is give these parties an opportunity to participate to them. But we have to, you got to set a deadline at some point.
Right, it's
Or
a deadline
you-
for you to make the request of the board, but isn't it up to the board or the hearing examiner, and ultimately the board, to make a determination as to whether they have properly elected?
Yeah, I would say yes.
Just I think it would make the letters, I don't know if you participated or listened to the hearing when board member Moon had concerns about misleading letters, giving people the impression that it's too late to join. I appreciate that AXIA is willing to work with these people, but it's not always clear to the owners if they don't get follow-up notices. Can we go to the, and then I have the same question and comment about these people that aren't leased, and I don't know where that exhibit starts within this bundle of stuff, but I noticed one to U.S. Trust Oil and Gas, where this is a different kind of letter.
Yeah, that's the letter to the unleased mineral owners. That would be Exhibit X.
And that kind of letter would have been sent to all of the unleased mineral owners.
Correct.
All right, and I just note that the exhibit says AXIA does not receive your response to this letter by June 8th. You will be deemed to elected not to lease and to not participate, and AXIA will commence compulsory pooling. I suppose that's exactly what you've done. Do you continue to work with these people? If you were to get contacted by them, would you continue to work with them to lease or participate?
Absolutely, and that is why we come to you with these amended average weight fee royalty calculations, because we get leases after the date that we initiate our forced pooling hearings. We get leases subsequent to that, and when we get them subsequent to that, we have to amend those to account for the new leases and the royalty rates on those new leases. So we do. We work with these folks up until the last day, but at some point we have to cut it off.
Sure, you need to give them warning and you got to get them moving. Would, in this case, you agree that anybody who leases prior to the board hearing, would that be a reasonable cutoff for this?
The only issue there would be having to file completely new exhibits.
Well, you'd have to recalculate the royalty. I'm not sure what else you would have to do.
The exhibits 1, 2, and 3, which list the parties that were seeking to compulsory pool, those would all have to be substituted and replaced.
Well, I don't. I mean, I agree that it would require some clarification, but I don't think it'd require entire new exhibits. I mean, you're going to do it anyway, right? If you get somebody who leases, you're going to amend your. And it would just be good to have a deadline rather than say we'll do it forever into the future.
Right. If we have a date set prior to the hearing, if it's a week before, and then we can file, something explaining, okay, since the date of this hearing and this date, they received these leases. These parties are no longer we're no longer seeking to compulsory pool, or something like that. So if a date was set prior to that hearing, possibly a week before, I think that would make sense.
Okay, and I don't need to tie you down. Maybe if you consult with your counsel, but I think the problem we have is it's not clear if it's as of this date or if it's solely up to your discretion. It seems like it should be clear on the record what the date would be.
What we asked for was up to this date. AXIA was by a sort of agreement with the division, was willing to wait until the August hearing to have it approved by the board, since we were doing a hearing examiner. It may or may not be typical in these situations, but so originally we were asking for this date. I think AXIA is perhaps being magnanimous and allowing, extending that even further. If that's the preference of the parties here, we can do that.
Well, is AXIA willing to work in the next few weeks before the actual hearing date, if people do come on board?
I have no issue with that. If we've got someone that wants to lease before that, we're good with that. And then, so that's not an issue to me. But there is a point where we have to cut it off because we have to go forward with our business.
Yeah, and I think as long as that doesn't require AXIA to take some sort of affirmative action beforehand and send out new letters and say, oh, wait, you've got 3 more weeks, hurry up, get them in. I don't think that would be fair. But if anything comes in, they're contacted, somebody reaches out to them, I think that would be
Well, I think the
acceptable.
larger parties, most likely the oil companies involved, are aware of the situation. And they would probably be the ones coming forward rather than the small interest owner.
Possibly. In some cases, mineral interest owners have been notified and they've been sent a lease if they find and go, if I want, let's give them a call and see if we can still
But one
do
of your
this.
large holdouts is Linn Energy, and it sounds to me like, Mr. Gallegos, you're working with them, correct?
Yeah, I am working with them, and what I told them is we give them extra time, so if they still want to participate.
Have you given that offer to other large mineral owners?
I haven't had that conversation I haven't had that request of others. But if they come talk to me about it, I don't have a problem with that. Yeah.
Okay, well, that
typically, though, let me say this, though, that typically we try to, and I will work with people all the time. I work with them up to the day before the hearing, and I guess I consider this the hearing. Yeah.
yeah, and if you want to say that's the date, that's fine with the division. We think there should be a date, and it seems your preference to have people lease or participate. So let's just be firm about it so that it isn't done on grounds that are outside of the requirements of the statute or special deals. That, I mean, I just think it's helpful to have a firm date. I would refer you to Exhibit I, Second Replacement Exhibit 1, I guess, not I. Second Replacement Exhibit 1, where you list the working interest unleased owners, and there's at least a dozen, if not 20 people there that you have said you've received, not yet elected to participate, not yet signed at JOA. I don't know if you mean by that that you're in negotiations with them or not, but some of them you said you are in negotiations with, included there is Linn Exchange and EP. So,
yeah. David, do you have that 3031? Can you pull that up so I can look at that if you've got it?
Yeah, it should be up on the screen.
Okay, if you go to the next page on that one. Yeah, let me kind of give you a little explanation on this one. 30 and 31 were both the ones that I said were the producing units. So what you don't see in there, what you see in there is minimal to no unleased interest. But these working interests, there's some of these companies, we can't even find that they're in business anymore. And we have tried to track down successors in some cases, and in some cases we've had, in a lot of cases, they just have not responded. And a lot of these, and I want to kind of give you the history on this, we acquired our interest from BBC here, and when we acquired from BBC on the first well, they weren't participating parties in that. So in regards to that list, we've already, we've talked to Bayless about it. We've had conversations with Arnold Engineering on it, and Arnold Engineering actually, we have purchased their interest, and that one needs to be dropped.
so Argo is dropped from your
Arnold
request?
Engineering.
Arnold Engineering, that's on page 2.
Okay, I'm on page 2 of Exhibit 1, not
Exhibit
I don't
1,
know, which is sections 25 and 26.
Okay.
I think if I can maybe speak to this or ask for some clarification or perhaps clarify, is your question as to that far right column where it gives a status update, That is your question. What does that mean? What's stated in that column?
Yeah, I mean, it's a long list of things, but if I'm looking at my Exhibit 1, Replacement Exhibit 1, on the second page, there's Argo, not the other one that you mentioned, Argo, I guess. And it says, elected to participate but not yet tendered AFA costs, not yet signed JOA. How do you want us to deal with that on this order? What is the status of that? And that raises the question about the others that are listed there. So that's, yeah, I don't know if you could just say categorically that none of those are going to be participating. I guess we could say that and cut it off today.
And we can say that and cut it off today. Let me tell you, historically, what I've done with these guys on the other units is, although I had a deadline on them, I've let them participate in the well. And I'm still trying to get a JOA out of some of them. But what this does, though, is when we go through this forced pooling hearing, it basically has them be subject to the terms of the JOA, but in each case, I've let them participate.
So let me get that clarified. So you've allowed them participate without signing the JOA?
That is correct, and they're deemed through the forced pooling hearing to be subject to the terms of the JOA. So even without signing it, and we've had that discretion not to, but we have allowed them to.
I guess, and this is something I just want to get clarified, and Mr. Alder brought up. There's two in there under the 2526. There's Linn, which you say you're working with, and most likely that'll come about, right?
Correct.
But then the other one is Argo, and they're listed under elected to participate, but not yet tendered AFE, not yet signed JOA. So my question is, do we force pull them or not force pull them?
I had a conversation with them sort of about this actually a couple weeks ago. So maybe in the interest of trying to help clarify, because I think there is some confusion on both sides. Maybe I can explain what our discussions have entailed. If they are still listed on these exhibits, the replacement exhibits 1, 2, and 3, and 4 and 5. They're still listed. AXIA would like those parties compulsory pooled, and that's why they're here today. This was a status update as to what happened. It shows that either they received the well proposals or offer letters, and then if they have responded or elected to participate, it shows that as well. But there has to be a cutoff date. And I think what Mr. Gallegos was referring to earlier, where in the past, even if a party was compulsory pooled, if they elected to participate prior to it, even though they were included in the pooling order, again, they were magnanimous and said, okay, well, if you get everything to us now, we won't impose the risk penalty, even though we're entitled to under this order.
So when is now? That's what we got to figure out. You say.
Right. So at this point, all the names that are on here, they would like compulsory pooled. If you want to set a date, based on the discussion we had earlier, if anything comes in, if we set it a week before the board hearing, that gives us time to prepare anything to let you know. These additional parties have come in. Then as of that date, any party still left on the exhibits, they would like compulsory pooled.
So, Mr. Gallegos, when they say on here, elected to participate, is that just a verbal you get from them, or obviously you got something positive?
That is a written letter from them with an election to participate.
But they don't follow up.
Right. In some of these cases, yeah, they haven't signed a JOA or haven't paid their costs. And so you still have to have a date that says, look, if you don't, and that's what the letter says, if you don't do these three things, if you don't sign the election to participate, submit or sign the JOA and submit the AFE costs, you're at risk of being compulsory pooled and having a risk penalty imposed. And so that's.
Okay. Sorry to interrupt that, Mr. Alder, but I just want to clarify that as we're going through that.
You are the hearing officer. So with regard, I would appreciate, I think that suggestion of a week before the hearing would be good. I notice on replacement exhibit 3, this is for sections 30 and 31 that you have in a sort of undetermined status. First Security Bank and J.P. Morgan Chase. First Security Bank is now operated by Wells Fargo, and I've been fighting with them for about 2 months to get them to respond to letters from me. So
Yeah.
I know how hard that can be, but if they had a little more time, sometimes those big institutions are slow to turn around. And I noticed you just barely sent the notice. Well, it wasn't barely, I guess it's almost a month ago, more than a month ago. But it wasn't sent at the same time as the others because it was returned with a different address. So that would help with those kind of people. Have you any comment about either of those, the First Security Bank interest on page 3 of Exhibit 3, Replacement 3, or the American Savings interest?
I'm sorry, would you repeat the question?
So looking at those two, they're listed on page 3 of the Replacement Exhibit 3 as having been returned for bad address and having been resent to a new address. Any follow-up since they were sent to the new address?
We have not been contacted by them. And what happened is, yeah, we sent it to the address of record and then realized when it came back that, hey, we need to find a better, these guys have probably changed, and we found a new address, and they've accepted it. It's went to the new address. We just haven't had any feedback from them. And I can tell you probably the reason we haven't had any feedback is because in this case, these interests are so minute, I don't even know if it's worth their time to mess with. And when I say minute, in a lot of cases, they're not even 1/10% or 1/10 of an acre. It's when you get down to these parties here, you're usually dealing with interests that are less than 1/10 of an acre. And a lot of time, they just don't bother with it.
Okay, and we probably beat that horse to death. What about on the JOAs that you testified to? I just wanted to clarify, are you saying that they are the same, each one, except for the well designation?
Well designation, yes, and the land description.
In all other respects, they're identical?
They are identical.
Okay.
And there's a portion in that where we refer to the well being drilled, and that's different. Any reference to the well is different. And now, also what will be different is your ownership in the
right.
in the
Anything.
JOA. Yeah. But other than that, it's pretty much identical.
Other than that, it is identical.
Yeah, I guess. Yeah.
It's the pretty much that while there's attorneys. You also testified that other JOAs you'd signed with other people in the unit were materially the same. What did you mean by materially the same?
Well, when I said they were the same, the non-consent penalty was the same, 400%. The ones that we're seeing from other operators in the area, and that would be Newfield and EP, are 400% penalty.
Okay, thank you for clarifying that. Do you know the internet searches that your landman used, any of them?
Yeah, I do. I've got them here. Let me grab it real quick. Get whitepages.com. I've got, these are the listings I was given, whitepages.com, ancestry.com, familysearch.org, and findthegrave.com.
Okay. That's all the questions I have. Appreciate your patience. Wait, just one second. Mr. Rogers, did you have any other questions? That's all.
Okay, thank you, Mr. Holder. Next witness?
Can I ask some additional,
Sure.
some follow-up questions, just to make sure that we have some of these clarified? Mr. Alder noted the importance of notice and concerns the importance of notice to the correct parties, and his concern related to those tracks where they were misidentified in the exhibit. I just want to clarify then, is AXIA seeking to compulsory pool any of those tracks or parties that were misidentified?
No.
Okay. And to your knowledge, with the understanding that the Trust Lands Administration has responded with an email, to your knowledge, of all the other parties that may have been misidentified, or did all those parties receive notice regardless of that misidentification, which occurred only in the exhibit itself, in the preparation of the exhibit?
Yes, with the exception of Sitla, yes.
Right, and they have since received a notice and responded with an email. Mr. Alder also spoke to the timing of the letters and some of the wording in the letters that states that you'll, in some cases it may have stated that you'll be deemed to have been, to be a non-consenting party and subject to a risk penalty. Is going forward to make sure that there's no confusion, is AXIA willing to sort of or willing to edit that paragraph so it shows
yes,
that?
We are, and I think what we'll do is say that really the intent there is to say, hey, if we don't receive this response, we're moving forward with a force pulling action.
Okay, thank you.
Yeah.
It's just a suggestion, but I think the board is concerned about that issue as well.
Yeah, and I have no issue with that. I appreciate that, and I can modify that really basically to say that if we do not receive this response, we will move forward with the force pulling action, and you will be subject to whatever the outcome is.
Okay, and one final question as to the interests that are now presumed to be owned by Wells Fargo Bank and J.P. Morgan Chase Bank, and the tract index, which is the primary repository for the real property records. Who was listed as the owner? Were Wells Fargo and J.P. Morgan listed as the owner, or its predecessor?
Its predecessor was listed as the owner, and those kind of are the master records. And really, when there's a change of ownership like that, the mineral owner should be filing something to put people on notice. But we realized that, and we did correct it. So
through discovery that those predecessors were no longer in business, through your own investigation, you realized that these were the successors or the presumed successors, because nothing was indexed against these lands in the tract index. So you realized that, and you reached out to them on your own, correct?
That is correct.
Okay. Thank you. Okay, I have no further follow-up questions for Mr. Gallegos.
Okay, thank you, Mr. Gallegos. Your next witness?
Taryn Frenzel. Let me go back let me get the proper page up here.
Yeah, we will stipulate to his expertise as a petroleum engineer in this matter.
Okay, thank you. That was going to be my question. Mr. Frenzel, can you please state your name and business address for the record?
Taryn Frenzel, 1430 Larimer Street, Denver.
Okay, and can you state your current position with AXIA?
I am VP of Completions and Engineering.
Okay, thank you. At this time, I'd like you to turn to or to look at exhibits J, K, and L, and ask if they were prepared by AXIA personnel or you, and reviewed with your input.
They were.
Okay. Let's go to Exhibit J first. Exhibit J contains 2 pages. The first page of Exhibit J, can you please explain what this is?
This is the AFE sent out for our Wasatch well. It is in the laydown area. Total AFE amount about $10.4 million.
Okay, and this pertains to which drilling unit?
25 and 26.
Okay, and you mentioned the total estimated cost there at the bottom right corner of that exhibit.
That's correct.
Now, the next page of Exhibit J, please explain this exhibit.
Yeah, this is the reclamation costs of the location and all equipment to totally bring it back to the way it was, about $200,000.
Okay, thank you. And again, this pertains to sections 20, the well in sections 25 and 26, correct?
That's correct.
Okay. Turning now to Exhibit K, explain this exhibit.
This is for drilling sections 33 and 34. This is again for our laydown. This is a 2-well pad with the Wasatch well that we just looked at. Uteland Butte, total AFE cost about $10.3 million.
Okay, thank you. And the next page.
Again, this would be the cost to P&A the well and reclaim the pad, about $200,000.
Okay, and within sections 33 and 34, correct?
That is correct.
Okay, and then finally, Exhibit L. Explain this exhibit.
Yes, this is a single well pad for sections 30 and 31. Total AFE cost about $10.1 million. This is for our Castle Peak well.
Okay, and the next page.
Again, this is P&A and reclamation costs for the pad, $200,000.
Okay, and the sections that this pertains to, where the well is located, are which sections?
30 and 31.
Okay, thank you. In your expert opinion, are the costs fair, reasonable, and necessary?
Yes.
Okay. I would like now can you please explain the risks associated with these 3 wells in light of the justification of the risk penalty that we've asked here for today, i.e. the 400%?
Sure. For the first 2 wells, the laydowns, these will be the first 2 laydowns in this area in the basin. So there is risk there. We have data that suggests that we are going the right direction here, but you never know until you drill a well what can happen. So there is an inherent risk on those 2 wells. The other one will be the first Castle Peak in the area and the first well in the 1280. So again, all of our data indicates that everything will be fine, but this will be the first one in this 1280, and there's always tweaks during the drilling completions on our new zone.
Okay. So in your expert opinion, considering the things that you just mentioned, the first horizontal wells and each of these, or long lateral horizontal wells in each of these sections, the fact that 2 of these wells are lay down wells, horizontal wells, then in your expert opinion, is a 400% non-consent penalty justified?
Yes.
Okay, thank you. Mr. Rogers, this concludes my examination of Mr. Frenzel.
Okay, thank you. Division?
Yes, I think Mr. Doucette has a few questions, but if I could first just clarify, were these AFEs that you testified to exhibits J, K, and L? Is it? Were those the same exhibits that were included with the letters that went out to the parties that Mr. Gallegos testified to earlier?
Yes.
Okay. If there's no objection, we'd ask for Mr. Doucette to be allowed to ask some questions of the witness.
If we could just kind of stay with the AFEs, J, K, and L. So as I look at that, it looks like roughly $4 million to drill and $4 million plus or minus to complete, or $4 million for your frac jobs. Is that correct?
That's correct.
And is this based off of, I guess, how many 1280s have you drilled to date? And are these numbers based off of your past history?
It is. We've drilled 5 wells so far, completed 4, and these costs are in line.
Okay. Maybe if you could go to Exhibit C. I don't know if there's that's probably the best one for this question.
Okay.
Just as far as number of wells in the area that have been drilled, I know this only has the 3 subject wells listed on it. Do you have any idea how many wells, and maybe in this extent, have been drilled, and what the nature of those wells are? Are they vertical, horizontal, etc.?
In 2 South?
In this general area that's covered by this map, I guess, in the surrounding area.
Directly south of us in 3 South, that is Newfield's program, there's about 70 to 80 wells, horizontal wells. They're all stand-ups. They are also contemplating going east-west on the west side. They're looking to participate in our well to see those results. They agree with us and go on the laydowns. As far as vertical wells, we have 8 vertical wells within our lands that we operate and own. And I don't know, there's 3 or 4 others. There's not very many within the southern part of 2 South. No other horizontals in this area. Crescent Point is doing a large horizontal program south of 2-1, a little bit to the west, south and west of us. All stand-ups.
Okay, so as far as the Newfield development to the south, is there a big difference between what you're doing here compared to that?
On our drilling standpoint?
Yeah, risk and drilling.
Fairly similar on our drilling standpoint. On a risk, we definitely have more pressure up here. As you move 2 miles to the north, pressure increases. On the completion side, we are putting in a lot more sand into these wells, and that, to get that kind of job away, does create some more risk in how much sand you can actually get into each individual zone and formation. And that's why every zone takes a little bit of tweaking to get the right design in there.
As far as, I guess, completion and number of zones, are they significantly different to Newfield's completions?
The Castle Peak, I'll talk to that one. Newfield has 1 Castle Peak well, so they're almost in the same boat as we are. So there's been 1 successful treatment in the Castle Peak, and we're going to repeat that up in our area. But again, we have a little bit higher pressure than what they're dealing with, so it may treat differently.
And did you say the 134 was a Castle Peak well?
The Castle Peak
That's correct.
is a 31-134, yes, sir.
And what were the other 2 wells?
The other 2 is the 34-34, which is the Utah Butte, and the 26-131, which is the Wasatch.
Okay, thank you.
If I could follow up on that. So the Utah Butte is probably the one that's been drilled the most by other operators, isn't that true?
That's correct.
And is there anything about drilling east and west as opposed to north-south, lay down rather than stand up, that increases the risk of these wells?
There is. First of all, pressure increases to the north. So when you go east-west, you see the pressure immediately. Typically, we drill wells. We start out with a 12-pound, end up with a 16-pound mud weight. When we go east-west, we have pressure from the very beginning of that well. So we have to control gas and shows all the way through, versus just, say, the last third of the well. The other thing is it's a laydown. So we have two fracture orientations out here, which is unusual, not for Utah, but is unusual in other basins. We have a maximum stress direction, which has fractures, and then we have a common east-west direction that has open fractures. On the laydowns, the east-west open fractures haven't changed. Those are still east-west, but the hydraulic fractures, we believe, are going to go north-south. So the risk is, do you have to cross those fractures with the drilling wellbore in order to access all those fractures, or will the hydraulic fracture do that for you? So that's the inherent risk. And even for us, even though we have a lot of wells in Newfield, we strategically drilled a north-south well just recently in the Wasatch, and we're going to compare that to the laydown well over here just to make sure we're not missing anything.
But is it, well, I didn't understand most of that because it's over my head, but I thought the reason that you went to laydown was that it was more compatible with the fracturing, which it changes as you go west, and that you would essentially be taking advantage of the fracturing in the same way that you do with the stand-up for the geology to the east. Isn't that true?
That is true, but keep in mind when we do a stand-up or a laydown, the east-west open fractures are still going east-west. They're still flat. So when we go stand-up, we're crossing all those fractures with the wellbore. So all that's changing is which direction the hydraulic fracture is going. And what might be confusing is typically these are the same direction. In other basins, the open fractures are the same direction as the hydraulic fractures, so it makes the decision easy. In this case, we're rotating based on the hydraulic fracture direction, and we're ignoring the fact that the open fractures are still going east-west, and we're going to connect those up with hydraulic fractures instead of the wellbore. We're most confident that we're correct, but that is a risk.
So just focusing on that risk factor, why are you requesting the same penalty for the stand-up well in the 30-31 sections as for the laydown wells?
The Castle Peak?
Yes.
The Castle Peak has not been done in this area. It's been done by one operator, one time, just south of us, and not nearly the job size that we're doing.
What do you mean not the job size? Was it 1280?
It was 1280, the frac size.
Right, so it's the same length of well, the one that was drilled to the south of you.
Correct. That is correct.
And in that, and in fact, in all of the Newfield wells, isn't it true that the risk penalty has been 300% as determined by the board in these forced poolings?
I can't answer that.
Are you aware of any 400% penalties that have been awarded by the board since the statute changed?
I'm not aware of anything on what Newfield
So
has
is
done.
there a reason, and I believe in other hearings, were you present at other hearings that AXIA has requested spacing or forced pooling, and you've testified in those hearings?
Yes.
And hasn't your testimony been, or at least the company's testimony been, that these lands are more expected to be more productive than the Newfield lands?
That's correct.
And that higher pressure is actually a good thing for...
It is, but it's got to be managed, and there is risk with it for sure.
So you don't expect a financial risk associated, it's more a production risk?
On the laydowns, it's more of a production risk, yes. On the Castle Peak, we do have higher pressure up here, so that has to be managed on the drilling side. On the completion side, there is a production risk in the fact that I can give my jobs away in a completely new formation.
All right,
And I can clarify a little bit more on a cost or financial risk. On any new zone, if I can't get the jobs away as planned, we screen out. With a screen out comes coil tubing and fishing. Every time the coil tubing unit shows up, it's $300,000. So there is certainly risk in a new formation, no question.
Okay, just one second. Thank you.
Can I just clarify something here? If the risk is so high, why didn't you choose to do stand-ups rather than do the laydowns?
It's risk reward. On the west side, we believe that the orientation is 30 degrees west of north. So if we're right, we are going to access more rock than if we would do a stand-up over there. Right on the section line, the township line of between 2 south 3 west and 2 south 2 west, we believe we're at 45 degrees. So at the township line, you could go north, south, or east, west and probably have the same well. But very, very quickly, as you move west from there, it rotates very, very fast. And that angle is hugely important on drainage. Our frac lengths will go the same distance out, but at 45 degrees, you're going to get chopped off 63% of your reserves because of that angle. So we want to be maximizing that. We believe that a laydown is going to produce a better well, but you do have the east-west open fracture trend that is different than the hydraulic fracture trend that we just don't know until you drill a well.
What is the fracture orientation there in the 33-34?
We just logged our well in the pad right in the middle of those 4 laydowns, and it was 30 degrees west of north. So it matches the data that we interpolated from.
Okay, thanks. Division, any more questions?
I guess I'll save it for argument. No more questions.
Okay. Mr. Bowler, you'd like to do your final argument?
If I could just do a couple follow-up questions. Sure. First, I'd like to ask, Taryn, is part of the reason that you asked, or that AXIA asked for a 400% non-consent penalty, is part of that reason did it have to deal with consistency between those?
Objection. That wasn't his testimony. He isn't qualified to answer that. You didn't ask it on direct. That's the argument that Mr. Gallegos tried to make, which I think is already in the record. I don't think he's an appropriate witness to answer that question.
Okay, I'll withdraw that question. Taryn, you previously you stated that in your expert opinion, you believed that for the reasons outlined that 400% non-consent penalty was justified, correct?
Correct.
However, in the request stated that AXIA was asking for a 400 non-consent penalty or whatever the board deems appropriate, correct?
That's right.
If the board deemed some other non-consent penalty appropriate, would other than the 400% that was requested, would AXIA object to that?
No.
Okay. And no further questions.
Okay. Would you like to summarize that?
Sure. I don't know. I can kind of do some final remarks. And then I guess ask for admission of exhibits after that.
Julianne, how would you like to handle that? You want to do that now, the admission of exhibits, or?
I think the division recommend that we do the admission of exhibits first, and then final remarks. Is that correct?
Well, I think it would be appropriate, so we know what we're arguing from.
Sure.
Okay. All right, let's do that then.
Okay, so we would move for admission of, I guess I'll give you a list them off here. It would be second replacement exhibit 1. Replacement exhibits, I'm going through the numbers first, and I'll get to the letters. Replacement exhibits 2 and 3. These are both replacement exhibits. Exhibits 4 and 5. Replacement exhibits 6 through 8, which were brought here today. Then moving on to the letters, the exhibits A through L. Replacement exhibits M and N. Exhibit O. Exhibits P through TTT. Exhibits.
Hold on,
Okay.
through TTT?
Yes.
Okay. You caught up, Julianne?
Exhibits YYY and ZZZ. And then, we discussed this earlier, the email from Levon Garrison with the Trust Lands Administration. I didn't bring copies. I showed it because we just received it. If we'd like to mark that as an exhibit, and then I can file the copies after this hearing.
So what we're going to call that one?
It would. I think that the next letter. So we had P through TTT. So I think the appropriate one would be Exhibit UUU.
Just sit letter.
Yeah.
Okay.
And then that would be it for.
Yeah, but how about those?
So the ones we're going to replace, which would be D, E, and F. But we don't have those prepared. Those will list. Have the correct tract identification plats. I think those were the ones you were just asking about. So,
okay,
because those aren't prepared, I can't. We haven't submitted them. We've just talked about doing them. I will submit them and file them.
Okay.
But as far as admitting them into evidence today, I don't think we can do that.
okay.
In the meantime, could we agree that the replacement exhibits, as they were called, will be admitted, and that the original exhibits will be admitted, and then if you file a replacement, that would just be added? I know that we're worried about confusion, but as I've looked at those exhibits, except for the fact that we have different track numbers, they are different information and they don't replace each other. And I think they have been testified to and should be part of the record. Be my request on if you could stipulate something like that.
Okay, which exhibits specifically are you referring to then? The 6, 7, and 8?
Well,
and
the exhibits
D, E, and
that
F?
are, yeah, the exhibits that are 3 pages, which
Okay, D, E, and F.
D, E, and F.
Yeah.
I think those should stay, and that the quote unquote replacement exhibits that state the percentage ownership, that's useful information, and show the changes in owner for those tracks. That's also useful information, but it's additional information. It should just come in.
I have no problem with that. It would show the evolution of what happened over time, and you at least would know what the final one was, but you could see the beginning one too.
Okay.
All right, Ms. Rowan?
I would appreciate that, I think.
Okay.
Can I just clarify something? I feel like I'm hearing an inconsistency. So what I heard you say is that the supplemental information would be just different numbering for the tracts, but I think what Steve is asking for is a little bit more than that. Are you tracking that he's asking for something additional just besides renumbering the 3rd page?
Okay, well maybe I need some clarification then what exactly he's asking for in that exhibit, because my understanding was that the problem was that the exhibits marked 6, 7, and 8 have the tracks numbered one way, and then the exhibits D, E, and F, those second and 3rd pages where there's a plat and then tracks, that those numbers don't match up with exhibits 6, 7, and 8. Is that not what has been requested to be submitted?
So you're just going to renumber D, E, and F with tracks that are consistent, or renumber 6, 7, and 8 with tracks that are consistent?
No, we would renumber D, E, and F because
Okay.
otherwise we'd have multiples. If we renumbered 6, 7, 8, we'd have multiple 1s, multiple 2s. So
Okay.
it's the D, E, and F that need to be renumbered.
So when we say renumbered D, E, and F, what would you call them? Because numbering and letters, I'm kind of confused here.
They'd be replacement D, E, F.
Okay.
Yeah, and Mr. Doucette says that would make more sense to him, and I think I confused myself. So yeah, that sounds like a good way to go. And
So just call them replacement exhibit? Okay.
so we're just changing one document. I thought you were trying to take out 6, 7, and 8 and put in something else, and I
No.
misunderstood. Okay,
Okay.
thank you, sorry. I
Yeah.
really apologize to Michelle. Good luck with this record.
Okay.
So if we're gonna leave in the original D, E, and F, should we call them supplemental D, E, and F?
Well, then that's
Yeah,
the
no,
issue.
we won't do that then.
We won't do that. We'll just
I
replace them.
misunderstood. I
Yeah.
apologize.
Replacement.
Replace D, E, and F. The first pages of each of those exhibits will be the same. The only thing will change is the track numbering.
But we will have the original D, E, and F in.
He said no.
You don't want that. Okay.
Right, but I guess, and I just wish that D, E, and F had been submitted with the original exhibits, because that was the information that was needed, and
D, E, and F were with the original exhibits. It's just they were improper. Okay, we
Let's
better
just-
stop before
let's just move
But
before
they
we
were
make
not-
this worse.
They were not
Okay.
clear enough, so we wanted to clarify.
Exactly, yes.
So they were there, but they weren't in a
Yeah.
state we could understand.
Yeah.
okay.
Okay.
I'm out of here.
Okay, where were we?
Okay.
Did we balance the exhibits?
So I believe that's all the exhibits. Did we miss any based on your record there? Julianne, I apologize.
I just wanted to clarify that exhibits D, E, and F are not admitted to the record, but we're stipulating that the replacement D, E, and F are admitted to the record once they're submitted.
Yes.
Is that correct?
Yes.
Yes.
And then, Mr. Hearing Examiner, would you please announce on the record that the exhibits are so admitted?
He has to first ask if I object.
Do you object, Mr. Alder?
No, to the extent that I understand it, I'm still confused, but
Oh, do we need to go over this again?
no, that's not. No objection.
Okay. All right, so we have taken care of the exhibits.
Sorry, I think Julianne say that those are so admitted.
Oh, okay, sorry. Yes, those are so admitted. Mr. Boulder, would you like to summarize?
Okay, final remarks. I'll keep this brief. We've because of the confusion and some last minute changes, we've kept everybody here for a long time. So I just want to state that the statutory and regulatory requirements have been satisfied. All the parties that were seeking to compulsory pool have received notice. They've had an opportunity to respond. We've had no objections or responses. And I would state that the requested relief is fair, reasonable, and justified, and we ask that the requested relief be adopted. Again, if Mr. Rogers and the division would like to set a date certain prior to the next month's regularly scheduled hearing, I would recommend that be August 16th, by which that date we will have, that would be the cutoff, and any parties remaining on the exhibits or either way, that those parties will be compulsory pooled because we need that date. I'd like to thank you for your time and attention and consideration of this matter, and I would like to reserve time for rebuttal if it's needed in this case.
Mr. Alder, do you have a division position?
Yes, I believe I do. So first of all, AXIA and Mr. Gallegos particularly. The notice questions are troubling to work through, partly because there are so many people. It's troubling to you and it's troubling to us. And frankly, the more information that could be submitted originally, the better, so that we know what efforts were made. And occasionally it appears that the minimum effort is to just give notice, and that's what the company's relying on. And so then we get into a lot of questions and back and forth. And having asked those questions and gone through the answers and cleared up some discrepancies, I think we can sense that AXIA has met the burden of giving notice, subject to allowing the time that you've stipulated to for additional responses to come in. But I would just, as the practitioner attorney that deals with these in the division, urge you to make that job easier for both of us in the future. Mr. Examiner, as to the penalty, the division feels that the board, since the statute was changed, has taken a stand that the 400% is to be considered an outer limit for particularly difficult wells, and quite often the argument has been made before the board that the 400% penalty is typical, that's normal in the industry, and that should be adopted. That's not the standard that the board has adopted in any hearing that I can bring to mind. Rather, the board has stuck to about a 300% penalty for similar wells. Granted, these are I think, an exception being east-west, but I don't think that there has been enough testimony as to the risk. The costs of the wells appears to be about the same. Certainly there are unknowns, but there are unknowns going in every well, and so the division believes that the testimony would support a non-consent penalty in the neighborhood of 300%. In the past, the division has not made a recommendation, but just has noted its concerns and left that to the board to determine. In this instance, where the hearing examiner needs to make recommendations, or else there has to be another hearing, I think the only way is for you as a hearing examiner to make that decision, and then the parties can object if they want when the findings of fact and conclusions are presented to the board. Accordingly, the division would urge you to find that these wells are typical of other wells that have been drilled in the area, that they in fact have been testified to be more productive and less costs, and that this company has indicated they're getting better at drilling these wells, and that they're moving forward with 3 wells at one time, which indicates a lack of concern. At least they're not waiting for the results of one well to drill the next well, and so we would urge you to adopt a 300% non-consent penalty. Thanks.
Any rebuttal, Mr. Bolden?
No. As I stated, somebody AXIA requested a 400% and feels that that's fair and reasonable and justified. But with the sort of understanding that the board can impose the risk penalty that it sees fit, but we think in no case does it merit anything less than 300%. And that's all.
I'd like to take a few minutes to discuss some issues with my counsel, if you can give about 5 minutes or so.
Sure.
What? Okay. Paul, give me the thumbs up. He's giving it to me. Okay. Mr. Gallegos, can you hear me?
Yes.
Okay, great. Well, we appreciate your time here today, and appreciate you setting things up over there in Denver on the electronic meetings. I think that's been helpful to you and us, and it makes these things much easier.
Very helpful to us.
Good, good. As I've gone over this, I feel that you've done your burden to locate these individuals, and that you've gone out of your way and done an excellent job with that. I'd like to go with the August 16th date. That's something we would look at as sort of the cutoff date. And I would urge you to look at those individuals that have expressed interest verbally or some way, Argo, Linn, and EP, and just see where they're at and maybe communicate with them that this is where they have at that point in time, because I think that would change. Those are larger mineral owners, I assume, when I look at it, and it could change things drastically. So I would look at doing that. So in the area of the penalty, as Mr. Alder stated, and we've been doing this as they changed the statute a few years ago from 150 to 300 to the 400, and we have yet seen a 400% penalty on a forced pooling. And we like to reserve the 400 for the highest risk possible, realizing all wells have the risk in them, but we feel that in this case that we will need to go with the 300%, which the board has done historically, and we feel these wells seem to be in a similar situation, and so we will go with a penalty of 300%. Mr. Bolda, if you could prepare that order with those issues we've discussed about, or any clarification?
Yeah, I'll prepare the findings of fact and conclusions of law and submit that to you and the division staff and anybody else that needs to look at it with that 300% as your recommended finding.
And obviously, if you don't agree with that, you have other means to pursue if you see fit.
Okay.
Anything else before us? Okay.
I would just note, and maybe I will note on the record, it was not clear what role the Division of Forestry and Fire and State Lands might have in with regard to the mineral interests that they manage. But you know that Mike Johnson represents them, and I think reaching out to them and getting that resolved before the 18th of August may be possible and would be helpful as well.
Yeah, we're not seeking to compulsory pool any interest associated with the Division of Forestry, Fire, and State Lands. I just know in the past they've had some issue about getting a consent and getting a lease in place, and if there already is one, then
there's already a lease in place over those lands.
Okay, yeah. I apologize. Thank you.
Okay.
Okay, a little confusion there. He said 18th. Did we agree on the 16th, or what was? 16th. 16th today. Okay.
16th, and I'll make note. All right, I'm trying to think of how this should work. Should we submit the findings of fact by the 16th with the final parties that we're seeking to compulsory pool? Do we submit the findings of fact earlier and then just submit a letter or something else on August 16th that states that, well, these are the correct parties, or these parties need to be removed? I'm a little confused on how that should play out procedurally.
Well, if I could speak in, I think the findings of fact are supposed to be filed by a certain date according to the rules, and you could say what conditions are included in those.
Okay.
I don't remember if it's.
But you'd have to have, by the time the 16th, you would have to be able to calculate your royalties and all that. And as my counsel said to me, if they are aware of the 16th as they're the day that they have to have it in, then that's going to put you under the gun because they may come in that day.
Yeah, no, I understand. Yeah, having to do all that at the last minute and get that into the findings of fact and conclusions of law.
So, I'm going to do a little research. research here.
Yeah, I think Mr. Alder's looking that up as well.
I really think the only ones that you will have any response from are those larger, you
The
know,
ones that have already
showed
elected.
interest.
Yeah.
And so maybe
but-
the sooner you could get them on board or get a decision out of them would be, help you out.
Certainly.
I don't see a date, but I think the sooner you got the findings of fact submitted, the better, because there's an opportunity to object to those, and
Okay, I'll put the conditions in the findings of fact, and note the cutoff date of the 16th, and that we will file whatever needs to be filed. I don't know how I'll word it yet, but you could review that wording.
So there
and
would
make
be
changes.
amendments possibly
Yeah.
before the 16th or after the 16th.
You'd
You'd have your finding of facts in earlier.
Yes.
And then after the 16th, you would amend it if there's any changes.
I think that's the way we've done it before. So this
Okay.
has been done before on here,
Okay.
Examiner Matters, where there was somebody that was left out, and the findings were
Okay.
filed, and it just provided as part of the findings that if necessary, there will be an update to the calculations based on additional parties joining the unit.
Okay. Everyone happy with that?
Yes.
Okay, before we conclude, is there anything else that we should bring up or division?
No, thank you. Sorry it went so long. I think that was my fault.
Mr. Bolden?
No, thank you.
Okay.
That's-
AXIA, we appreciate you being there.
And,
Thanks.
Okay.
and thank you for allowing us to do it this way. It saves us a trip and an overnight stay, so
Okay.
we appreciate it.
Okay, thank you. All right, we conclude this matter today. Thanks.
Thank you.